Okay, hey you guys, I'm back with an update. Now, as I told you on the last broadcast, Jay-Z wanted Jane Doe, who's accusing him and Diddy of rape, wanted her to come out and say who she was because she did that interview. Well, it looks like the judge has ruled, and guess what? It wasn't in favor of Jay-Z and Alex Spiro. So let's get into it. And please don't forget to like, share, and subscribe. Okay, so Tony BuzBee gains the upper hand over Jay-Z and his attorney, Alex Spiro, in judge's new ruling. So the explosive drama about the anonymous assault lawsuit against Jay-Z and Diddy continues to leave some stains on the holiday season. Moreover, per reporter Megan Cuniff, Judge Torres recently made a crucial decision in her latest ruling on the case. This concerns the Roc Nation boss's attempt to reveal his accuser's identity. For those unaware, Hove and his legal team, mainly his attorney Alex Spiro, attempted to dismiss this case as quickly as possible and launched many accusations of extortion, defamation, unethical practices, and more against the plaintiff's lawyer, Tony BuzBee. But it seems like we will have to actually see this all play out in court. So Carter's lawyer's relentless filing of combative motions containing inflammatory language and all of these attacks and whatnot, they say it's inappropriate, a waste of judicial resources, and a tactic unlikely to benefit his client. I'm sorry, didn't I just say all of this? Didn't I literally say that he was just wasting Jay-Z's time and, running up the clock on his money, basically draining him of his money because all of these motions he's filing are not going to go anywhere. And even if Jay-Z wins the civil case against the accuser, it's not going to have anything to do with these nefarious, allegedly frivolous filings that Alex Spiro is putting on Tony BuzBee. Okay, please pay attention. Now, it goes on to say, this tactic is unlikely to benefit his client. Okay. The court's ruling on Jay-Z, Alex Spiro, and Tony BuzBee's debacle. This is what it basically says in the paperwork. The court will not fast track judicial process merely because counsel demands it. In addition, Judge Torres also pointed out the various areas in which Spiro failed to follow the court's rules. Well, imagine that. I'm sorry. How many times have we heard this about him? And you heard it here first. Now, as that's exactly what he and the Brooklyn rapper accused BuzBee of doing. Isn't this everything that I literally said verbatim? Now, mind you, this just came out minutes ago. I want you all to pay attention because you need to start listening to the queen. Furthermore, this adds to a lot of the other legal moves, accusations, and character attacks that emerged in this war between Jay-Z, Alex Spiro, Tony BuzBee, and his client. BuzBee himself faces a litany of lawsuits from former clients or folks on the other side of the courtroom, and they range from scandalous gossip to more contractual complaints concerning his alleged business and legal practice ethics. Now, on Jay's end, there's similar heavy claims. Of course, it's hard to call exactly how many cases and allegations will actually see a resolution. Okay, but with that all being said, we'll have to see how fast or slow 2025 moves along in the courtroom. Meanwhile, this legal combat between Jay-Z's team and Tony BuzBee's camp also threatens sanctions against the latter, which he vehemently opposed and advocated against. Even if we don't have a lot of concrete updates to talk about, okay, at least we have this one. It seems like this will continue to go forth in court until further notice, and everyone's waiting for concrete information. All right, please pay attention. Now, that was just the article, but I actually have the court documents. Okay, so let's get into it. I'm going to share my screen. Likes up, everyone, please like and share. And just remember that you heard it here first. All right, so now here's what happened. Put my watermark on here. Okay, so now here's what they say. Now, this was filed today, okay, 12/26/24. Plaintiff Jane Doe filed this action on October the 20th of 2024, alleging violation of New York City Victims of Gender-Motivated Violence Protection Act. Now, by order dated November the 6th of 2024, the court provisionally granted plaintiff's motion to proceed anonymously, explaining that defendants had yet to appear in this matter and that the balance of interest weighing for or against anonymity may shift as her suit continues. Now, on December the 8th of 2024, plaintiff amended her complaint to add Sean Carter, known professionally as Jay-Z, as a defendant. Plaintiff again sought leave to proceed anonymously, but this time Carter's counsel appeared and sought appeared and moved to deny her motion, or in the alternative, to dismiss her amended complaint pursuant to Federal Rule of Civil Procedure 12B1. Now, Carter also moved for an expedited hearing on the issue. The next day, Carter's attorney filed a letter containing a declaration from an associate at his law firm recounting a phone conversation that she had with an unnamed woman who claimed that plaintiff's counsel encouraged her to lie about her experience of assault. Carter's attorney or lawyer asked the court to consider this additional information in connection with plaintiff's motion to proceed anonymously. Plaintiff's counsel denied Carter's allegations against him. Now, on December 13th of 2024, Carter's attorney filed an additional letter alerting the court to a recently published interview of plaintiff on NBC News. In the interview, plaintiff, speaking anonymously, explained her allegations against defendants and her reasons for coming forward now. Carter's lawyer points to the interview in which plaintiff admitted to inconsistencies in her story as evidence that plaintiff's claims have no factual basis whatsoever. He also argues that plaintiff's counsel violated Federal Rule of Civil Procedure 11B by failing to undertake a reasonable inquiry into the facts behind filing the complaint and failing to seek admission pro hoc vice to this court. Carter's attorney requested an expedited briefing schedule for a motion to strike the first amended complaint under Federal Rules of Civil Procedure. The next day, Carter's counsel submitted yet another filing, a motion for an emergency order directing the preservation of evidence and striking the amended complaint under Rule 12F. Motion to proceed anonymously. Now, in deciding whether a plaintiff may proceed anonymously, courts balance the plaintiff's interest in anonymity, they balance this against both the public interest in disclosure and any prejudice to the defendant. The Second Circuit has laid out a non-exhaustive list of factors to be considered. Now, so she, like I told you on the last broadcast, Jay-Z doesn't feel like she should be able to remain or to continue using anonymity because, for one, she did that interview, which makes no sense because we didn't see her, nor did we find out any more information about her, such as her name or any of that, during that interview. Now, number one, whether the litigation involves matters that are highly sensitive and of a personal nature. Two, whether identification poses a risk of retaliatory physical or mental harm to the party seeking to proceed anonymously, or even more critically, to innocent non-parties. Now, these are the things that the court takes into consideration when determining whether or not a person should be allowed to move forward anonymously. Okay. Third, whether identification presents other harms and the likely severity of those harms, including whether the injury litigated against would be incurred as a result of the disclosure of the plaintiff's identity. Whether the plaintiff is particularly vulnerable to the possible harms of disclosure, particularly in light of her age. Whether the suit is challenging the actions of the government or that of private parties. Whether the defendant is prejudiced by allowing the plaintiff to press his or her claims anonymously. Whether the nature of that prejudice, if any, differs at any particular stage of the litigation, and whether any prejudice can be mitigated by the district court. And here's the thing that they are obviously not thinking about. And by they, I mean Jay-Z and Alex Spiro. You see, it could quite possibly be perceived by the court as a danger for her to release her identity. See it as how she's also accused not only Jay-Z, but Diddy as well. And we've heard the courts time and time again, when they've denied bail to Diddy, say that he has engaged in witness tampering, obstruction, and that he, in fact, is a danger to the victims and the witnesses. Okay, so can you see why the judge would not rule in their favor? This was just a waste of time. And I'm sure, now this is my opinion, that Alex Spiro knew this was a waste of time. But as I said, him filing all of these papers and everything, all of these motions, this is just running up the clock on Jay-Z. Not running up the clock, but running up the tab, shall I say. Now, whether the plaintiff's identity has thus far been kept confidential, whether the public's interest in the litigation is furthered by requiring the plaintiff to disclose her identity. And the ninth thing, whether because of the purely legal nature of the issues presented or otherwise, there is the atypically weak public interest in knowing the litigants' identities. And 10th, whether there are any alternative mechanisms for protecting the confidentiality of the plaintiff. Now, goes on to say a court is not required to list each of the factors or use any particular formulation as long as it is clear that the court balanced the interest at stake in reaching its conclusion. Now, here, the weight of the factors tips in favor of allowing plaintiff to remain anonymous, at least for this stage of the litigation. Factors 1, 2, 4, and 7 weigh strongly in favor of anonymity. In her amended complaint, plaintiff alleges that defendants gave her illegal substances and then raped her, okay, when she was only 13. So by the fact that she was a minor plays a significant role in this. Courts in the district have recognized that allegations concerning SA are highly sensitive and of an extremely personal nature. And then they reference a myriad of cases that explain this. Now, plaintiff is particularly vulnerable to the possible harms of disclosure. According to her amended complaint, she continues to experience depression, post-traumatic stress disorder, and a seizure disorder associated with the stress of her assault. And as I told you before, and I proved to you with receipts, that people with autism absolutely can have seizures due to stress. Now, with that all being said, denying disclosure in part because of the risk it is posed to plaintiffs' already fragile mental health. Moreover, plaintiff's counsel asserts that many of his other clients who have filed similar lawsuits against Sean Combs claim to have been threatened by Mr. Combs for their decision to speak out. Okay? Now, and finally, although plaintiff sat for an interview with NBC News concerning her case, NBC allowed her to conduct the interview anonymously. Didn't I also point that out on the last broadcast? Please pay attention. Granted, several factors weigh against allowing plaintiff to proceed anonymously. Plaintiff is challenging the actions of private parties, not the government, and given the media attention surrounding this case, the public has a substantial interest in this litigation, separate and apart from its general interest in an accused being able to publicly confront an accuser. All right. Now, alternative mechanisms may exist to protect confidentiality, namely the redaction and sealing of documents. Most importantly, plaintiffs' continued anonymity may cause prejudice to defendants, making it more difficult for them to collect the facts necessary to mount a defense and, as appropriate, challenge plaintiffs' credibility. Now, identifying the most significant form of prejudice to defendants as the discovery disadvantage that plaintiff's anonymity would present. Okay, this could be a factor. Now, the court does not take such prejudice lightly. Nevertheless, at this exceedingly early stage in this case, the factors counseling against disclosure outweigh those that counsel in favor. So they're saying on the one hand, it could be a problem and it could be dangerous, stressful, or any of those things to make her say who she is, to force her to come out into the spotlight and show her face and tell her name because of the allegations against Diddy, where people have already alleged that he's threatened them. They've been coerced. They've been, some people claim that they were, or there's been speculation that people were offered money, like Kalina Harper. And more importantly, people saying that they've been threatened nonetheless. And let's not forget those two people. We don't know if they're private investigators or who they were, that were going around to some social media content creators and asking them, to change their stories about Diddy. So all of these things are problematic. But then on the other side, they're saying that if they don't make her say who she is, then that could in fact, make it a problem for the defendants to basically, defend themselves, for their counsel to defend them, because they don't, this gives them a disadvantage, basically. So with that all being said, it goes both ways, but as the judge is seeing it right now, it's more of a problem if the judge were to force her to reveal her identity, because that could definitely put her in harm's way. And they can't deny that, because the thing is, they've already denied Diddy bail 3 times because of him supposedly being a danger. So how would it then look for them to force someone to come out and say who they are, specifically someone who claims to have been a minor when certain things happened, and also someone who is intellectually disabled? Now, accordingly, plaintiff's motion to proceed anonymously is granted. Plaintiff is advised that because the balance of these factors will certainly shift as this case proceeds, especially if and when the parties engage in discovery in earnest, the court intends to revisit this decision at a further date. So later on down the line, maybe they'll make her go ahead and say who she is, as they get to closer to the discovery portion of the suit. But as for now, she's not having to. Now, since Carter's attorney first appeared in this case 17 days ago, he has submitted a litany of letters and motions attempting to impugn the character of plaintiff's attorney, many of them expounding on the purported urgency of this case. Now, goes on to say that requesting to be heard on an expedited basis and accusing plaintiff's counsel of exploiting the legal process to generate media attention, asserting that plaintiff's counsel seeks only to benefit himself, requesting the shortening of the deadline from 21 days to 1 day, describing plaintiff's counsel as willing to blatantly violate the core ethical obligations of all attorneys, and requesting a hearing on a motion the following day. Now, Carter's lawyer his lawyer's relentless filing of combative motions containing inflammatory language and ad hominem attacks is inappropriate. It's a waste of judicial resources and a tactic unlikely to benefit his client, as I told you all already. Okay, now the judge clearly agrees with the queen. I just want you all to pay attention because you heard it here first. Now, the court will not fast track the judicial process merely because counsel demands it. Moreover, although Carter's attorney assails plaintiff's lawyer as having a chronic inability to follow the rules, Carter's counsel has failed to abide by this court's clear rules. Isn't that what I also told you? I said, look over there, don't look over here. That Alex Spiro's putting the finger of blame and shame at BuzBee and trying to call him out for unethical practices. But in fact, isn't he the one engaging in unethical practices? Please pay attention. Now, at the end of the day, under the Carter's individual practices in civil cases, and with limited exceptions, a pre-motion letter is required prior to the filing of any motion. Although Carter's attorney stated that he intended to file immediately a motion to strike the First Amendment complaint under Rule 12, he did not give plaintiff the requisite 5 days or the 5 business days to even respond. Okay? So individual practices wait for the court to set a motion schedule or state whether any exception to the court's individual practices applied. This is unacceptable. Counsel is hereby advised that any further motions filed in violation of the court's individual practices may be denied on that ground alone. Because what is he doing? He's filing BS motions, okay, that make no sense. And as I told you, it's just making him get more money out of Jay-Z's silly self. And it's just too darn sad that Jay-Z didn't figure this out for himself. Now, lastly, although Carter's attorney is entitled to file a Rule 11 motion without first seeking leave of court, individual practices, okay, the court discourages this approach. If he still intends to serve plaintiff with a motion for sanctions, the court denies his request to shorten the safe harbor provision contained within Rule 11C2 from 21 days to 1 day. Now, the footnote says, on the merits, Carter's motion to strike is denied. Motion to strike under Rule 12F are generally disfavored, and will be granted only if there is strong reason to do so. And then they cite the case Abdu versus Walker. Right now, Carter's motion, which summarily asserts that plaintiff's claims are baseless and salacious, does not clear that high bar. So Carter's motion to strike amended complaint under Rule 12 is denied. By January 10th of 2025, plaintiff shall file her response to Carter's motion for an order directing the preservation of evidence. By January the 17th of 2025, Carter shall file his reply, if any. The clerk of court is respectfully directed to terminate the motions on ECF. Okay, I want you all to pay attention. It is so ordered, dated December 26th of 2024, and this is signed Judge Annalisa Torres. All right, so there you have it right there, beloveds. At the end of the day, All of those shenanigans that Jay-Z's attorney, Alex Spiro, tried to pull, none of it worked. And in fact, it backfired. Okay? Just as I knew it would. All right? You are going to learn to start listening to the queen. Okay? I haven't been wrong yet. I haven't been wrong yet. The judge said exactly what I already told you prior. So with that all being said, please be sure to like, share, and subscribe. Hit that like button. It's the best way to support the channel absolutely for free. And I love you all to life. Okay, until next time, I will talk to you all again soon.